whatever you think is appropriate.
Okay. Ladies and gentlemen of the jury, my name is Levi Harris, and I am counsel for the plaintiff, Flinders Aluminum Company, and Mr. Arthur Jackson. Arthur Jackson has paid insurance premiums on a fire insurance policy for 11 years. And when his business burned to the ground, when he finally needed that policy to come through, the insurance company refused to pay out on the policy. Mr. Jackson is married to his wife Janice. They have 3 children, Phyllis, who's 12, Harry, who's 10, and little Ambrose, who's 6. And Mr. Jackson has owned his business since 1991. He's a graduate of Nita City University with a master's in business administration, upstanding member of the community. The fire that destroyed his business took place on November 16th, 2 years ago. One of the employees of Flinders Aluminum Company died in that fire, and Mr. Jackson lost everything. As far as what could be salvaged from the fire, everything was lost, burned to the ground. As regards his insurance policy,
Okay, Levi, thanks. That's a good minute.
We got to do them individual or critique them at the end?
Yeah, I think, well, just let's talk individually. We've got lots of time.
Okay.
If it's all right with you.
Sure, it's fine with me, Judge. Well, you're lucky because it came out of the box. The jury hasn't heard any more of these opening statements. You did a great job on trying to personalize, humanize your client.
the Flinders Aluminum Company had been losing money for the past 2 years. Mr. Jackson had gone to the bank repeatedly during the month of October to ask them to refinance the loan that was coming due at that time. He told Mr. Anderson at the bank of a new plan that he had to bring his business back to be the vibrant corporation that it once was. He told him, you know, of new plans to make aluminum parts for cars, to retool the whole business, and yet repeatedly the bank put him off and was not willing to refinance his loan or to grant him new loans so that he could get his business back on the right track. And then, you know, 16 days into the month of November, after he had tried to get that loan refinanced, his building burnt to the ground. He lost everything that he had. You're talking about a man who's invested 13 years of his life into a business, depended upon an insurance policy to come through for him, and now here he is, he's lost everything, and the insurance company isn't there with the money that he had relied upon. And so at the end of this trial, what we're going to ask is that you would grant him the relief that he's prayed for, and that is to ask the insurance company to perform its obligation and to carry out its contract to Mr. Jackson and to the Flinders Company. Thank you. I'm here seeking payment of his insurance policy on the building that burned down, Flinders Aluminum Company. Mr. Jackson had paid his insurance premiums faithfully, on time, for 11 years. And when his business burned to the ground, when he finally needed that policy to come through for him, the Mismo Insurance Company refused to pay out on that policy. Mr. Jackson is a married man. He has 3 children, aged 12, 10, and 6. He has owned his business since 1991. Before that, he went to Nita City University and he graduated with his master's in business administration. The night of the fire, November 16th, Mr. Jackson was working late, and other employees were working late into the evening, and because of this, when the building burned down, one employee, George Avery, actually perished in the fire. When that building burned down, Mr. Jackson lost everything. He lost the building, he lost the equipment, and the company is not in operation today because they have no means to keep carrying on production. Now, as to the policy that covered the fire insurance. Mr. Jackson had had that policy since January 1st of 1993. Originally, it was set for $835,000. 6 years ago, he increased that to $1,125,000. And later, in October 2002, he increased that policy $500,000 more dollars. But this is a policy that he has had, since he began his business at Flinders. Now, the defense would have you to believe that Mr. Jackson set this fire, that he had somebody set this fire, and that because it was arson, according to their claim, the insurance company doesn't have to pay. But the contract is invalidated. One of their witnesses, Marie Williams, only went to the police with her story of a suspicion of arson after she had been terminated at Flinders Aluminum Company by Mr. Jackson. And even among the fire marshals who investigated the claim, there are differing opinions about what may have caused that fire. The defense, Ms. Moe, would lead you to believe that because of Mr. Jackson's financial problems, it's more likely than not that he had this fire set to be able to collect on insurance. It is true that Mr. Jackson's company owed $400,000 to the bank. And it is true that in the past couple years, they had lost $1 million in their business, in the regular course of their business. But Mr. Jackson, rather than being, having other plans, let's say, was going to the bank even up into days before the fire, again and again, repeatedly, to ask the loan officer to refinance his loan and even to grant him another loan. He had hired this George Avery, the man who perished in the fire, to design a new program to bring this company back from the financial situation that it was in, and to actually retool the business so that they could make parts for automobiles instead of just for windows and for siding. Mr. Jackson had a plan. Mr. Jackson was going to the bank repeatedly to seek refinancing, to seek financial assistance to get his business back on its feet. And unfortunately, November 16th, his plans to get the business back and to pay back the loan, to refinance the loan, all of those things went up in smoke with his business when it burned to the ground. And now, after he's lost everything, after his plans to bring this business back, this business that he has nursed, that he has given so much of his time to over the past 13 years, the insurance company refuses to pay out on the policy that he had kept current and wants you to believe that Mr. Jackson set this fire himself. We would ask you, after this trial, after we presented the evidence and after you have had an opportunity to consider all of it, we would ask you to return a verdict for our client, Arthur Jackson, and the Flinders Aluminum Company, and to grant him the relief that the insurance company owes him. Thank you. I'll listen to my neighbor. You think they've got it figured out? Huh? Okay, I'm Levi. Chief Olson, isn't it true that Arthur Jackson told you he left about 7:30 from the Flinders that night?
Yes.
And isn't it true also that the report of the fire came in at 8:30?
Yes.
So you don't know what time that fire may have started between 7:30 and 8:30 that evening?
No.
So from that, you have no way to say that this was a fast-burning fire. It may have started at 7:31 and burned until the time you got there.
No, because of the chemical reaction involved in the chemical reaction that I believe took place and the type of fire that burned would indicate that it was a very fast-moving fire. And that
But you don't have a witness to testify to that. to testify to seeing the fire burn quickly.
Yes, the person that saw the fire that was there and called in the fire, Allison Smith.
Okay, let's move on past that then. You didn't testify, you didn't include anything about the weather in your report. If there were wind that night, wouldn't that have helped the fire to burn more quickly than it would have otherwise?
Objection calls for speculation.
That is within the expert's realm of expertise.
Possibly.
Let's talk about things that you haven't included and that you haven't testified to yet today. You speculate that you conclude that there was a time release device. You haven't found this time release device.
No.
The spalling marks on the floor, the scarring marks, could just as easily have been caused by water cooling a hot floor as, say, splash marks.
No, that's not true.
Okay. You didn't check Flinders' records to see how much acid they had on site.
This is true.
You don't know who's in charge of storing the acid at the Flinders Company.
No.
You didn't find any trace of an accelerant or hydrochloric acid on Mr. Avery's clothes.
No.
Even though you conclude that he must have splashed it all around the room.
Right.
Starting a machine, firing up a machine in a factory like this could cause a spark that would cause an explosion.
No, because hydrochloric acid in and of itself is not flammable.
If there were a metal spark that flew off of one of these machines.
Possibly.
You don't know that Mr. Avery didn't stop to plug a leak in a barrel of this hydrochloric acid.
No, I don't know that.
Matter of fact, you don't know that these very same circumstances that you conclude was an arson could have been caused by an accidental explosion. For certainty.
No, I don't conclude there was an accident. I conclude that it was an arson.
But you can't say for certain that it wasn't an accident. These circumstances could just as easily have been an accident.
No, I can say more likely than not.
The prior fires that you say Mr. Avery was involved in both included hydrochloric acid, is that true?
Yes.
But these were both in factory and production type situations where hydrochloric acid would be used anyway.
True.
And finally, you never had enough information to charge Mr. Avery of any crime in the past or now, correct?
Correct.
Thank you.
He ran on you in the beginning.
It's not done in this case, it's you.
Well, what should have waited until after I was finished?
The ball's in your court.
I'm gonna have an aneurysm or something.
Oh, no.
I don't want to put you under any pressure.
Well, I was gonna go first. I was gonna do the, the introductory stuff until I found out we're not doing that. So here I am. Anyway, Mr. Pincus, Chief Olson's report says that he suspects there was a timer involved in this fire. How often do you find timers in arsons of this nature?
This nature, there will be you cannot specifically state how many components of the timer that you will find, but they will leave some type of physical evidence if he did a thorough investigation, perimeter search on his part.
How do you sometimes find timing devices then?
Most time.
Okay. What do you make of Mr. Avery, the deceased, position there under the rubble?
I don't. Under the rubble there, with the coroner's report, with the first and second degree burns and such a fire of this magnitude and the heat that was produced, to actually look like a couple of the pictures that had melted steel, which that's going to take 1100 degrees Fahrenheit to do. I'm not a coroner by any means, but his injuries don't coincide with the scene.
Okay. Chief Olson's report says that he imagines there was splashing of an accelerant around the floor. In fires where there is an accelerant that's been splashed around, what types of markings do you see on the
They
floor?
leave distinct fire patterns. We call them, you can go lines of demarcation, which will be when the accelerant or the liquid is superheated, it will actually embed itself into another solid. In this case, it's concrete. They're very distinct patterns. Pour patterns and splash patterns are very distinctive.
Do you see those types of patterns here?
No, I did not.
How about on the arsonist person? What would you expect to find about him if there's been this splashing of an accelerant around?
I would expect to find some types of remnants of accelerant on his body or on his person via his clothes, shoes, whatever personal effects he had on.
Okay. If you had conducted this investigation from the beginning, how would you have gone about it differently as regards to what you put in your report?
My reports were very thorough, and generally on a room and content fire, it'd be close to a 45-page report with documentation of everything. I did not see any documentation on his report of times, who was on the scene, a log of police, fire, news media. They should be logged in there for talking a possible criminal act here. His documentation with the photographs is very vague. So basically right now it's a puzzle without half the pieces.
What might you have said about the weather, for instance?
Weather's very important in determination on a fire scene. In a building of this magnitude, built in 1913, obviously very drafty. It was November. A lot of times cold fronts come through, 30-mile-an-hour wind. It could have promoted some of the ventilation issues that Mr. Olson here is debating in his report.
What types of records might you have wanted from the Flinders Company to investigate this if you were going at it from an arson's perspective?
I would definitely know their inventory of their materials, which that's standard. They have to be able to supply those every 30 days to fire marshals. I would know their delivery schedule. I would need to know how much material is actually in the building on that given day. I would need to know payroll, work schedules. Was this Mr. Avery's normal work time? What was his job? It's a multitude of things that aren't in here.
What other types of photographs might have helped an investigation like this?
Well, basically, like I said, I do an exterior 360, then I do an interior 360, then we go from least to most. And his area of origin, he's not documenting into a close-up view to be able to turn some of these patterns. There are patterns that are very distinctive from his photos, but I feel if we'd have got closer and he'd done a more thorough documentation through photographs, I believe we could have found something.
Are there any technical detection devices that you would have used in a situation like this?
Well, like I stated before, I always use a hydrocarbon detector, which will detect accelerants, gasoline, kerosene, diesel, etc. like that. Alcohol, there's no place in his report that he did use a hydrocarbon detector. He merely scooped up ashes. How, I don't know if he put those in a clean metal can to be sent back to the laboratory, if he put them in a paper bag, which will have a very huge detrimental effect on the ashes itself. How are the ashes loaded into the evidence can? Was it with firefighters? Nothing here is documented in his report.
Let's move to your experience as a fire investigator. What types of things besides arson could cause fires of this nature? Have caused them in your experience, let's say that.
There's a numerous amount of accidental causes that could be. In buildings of this age, faulty wiring, human error. I know hydrochloric acid, once it combines with any type of hot ferrous metal, it can combust. It's not flammable by itself, but it can combust. And there's nothing in his report with the protocol of the company that would state the hydrochloric acid, it was in a drum. What type of drum? Is it open? Is it closed? Was there possibly any type of MSAD report made? There was a spill. There's nothing in here to signify that.
How about the way they went about cleaning and keeping things tidied up around there? Might that what effect might that have had?
Huge effect. Dust is one of the most volatile combustion materials there is. A huge buildup of dust, any type of a spark or any type of radiant heat can combust, and an explosion ensues.
So in your opinion, looking at these facts, do you believe that this could be said to be arson for any degree of certainty?
Not at all. There's not enough investigative work going into the background, as what materials were stored there, how much. It's just a multitude of factors and facts that aren't in this report to make a 100% declaration that it was arson. So no, not at all.
So in just a few words, how would you describe this report as it relates to thoroughness?
4.
If you filed a report like this, how would it be received?
I'd be fired.
Thank you.
Yeah, I think you did. You're getting better each time I hear you.
Burns in a magnitude like that. That's why I interviewed the first-in firefighter.
This man paid his insurance premiums for over a decade, faithfully. And when he needed that insurance policy to come through for him, when he needed the money, when he needed the insurance that this company had promised him, that he had paid for, it wasn't there for him. What happened that night is simple. We had an insurance policy that was in force at the time of the fire. The premiums were current. The fire burned the place to the ground. We've proved, as the plaintiff, what we need to prove in order to recover on this insurance claim. Now, the defense, Mismo Insurance Company, has raised what we call in the law an affirmative defense, which is that they don't have to pay on this claim if it was proved to be arson, and if it was proved to be caused by Arthur Jackson or one of his agents. But they carry the burden of proof for that claim. They have to prove to you, in your minds, as the jury, that it was more likely than not that Arthur Jackson or one of his agents set this fire on purpose. And the plaintiff contends that they have not met that burden. Now, there are several facts that are in dispute. You've heard all of them in witness testimony. You've seen the exhibits. Mr. Jackson was not a perfect man by any stretch of the imagination. He had family problems, indiscretions with his secretary, but that does not mean that he's an arsonist. That does not mean that he is a criminal. His personal life is not the issue in this trial. You've heard often from Ms. Moe, in fact, it's the bulk of what they've been saying in this case, that Mr. Jackson was in financial trouble. That doesn't make him a criminal. Just because he happened to be in debt, just because he had this loan coming due, does not mean that, now that something bad happened to him, that his business burnt to the ground, that he set that fire. If I had a wife, which I don't, but if I had a wife, and we fought, and she drove off angry, and then had a car accident, that doesn't mean that I, cut her brake lines. It doesn't mean that I caused her death. Just because one fact happens after another does not mean that one caused the other one. And why would Arthur Jackson try so hard? Why would he go so many times to the bank right up until before the fire to get a refinancing on his loan, to get a new loan for a new opportunity for his company if he was going to turn around and burn it down anyway? It doesn't make any sense. As to the arson and to the evidence that the defense is proffered to prove it's arson, you have Chief Olson's report, who our witness, Mr. Pincus, testified if he had filed a report of that nature, so incomplete, so full of holes, so speculative, he would have been dismissed from his position. Mr. Olson's report included nothing about the weather. There was nothing about what the wind speed was that evening. There was nothing about whether it was snowing, whether it was raining, whether there was lightning. Nothing of that nature. Mr. Olson's report didn't include any mention of a use of a hydrocarbon detector that would have detected gasoline or kerosene or anything that we typically think of when we look at arson and investigate these types of things. He didn't follow procedure. There was no rhyme or reason to the way that he went about his report or his investigation, at least as far as evidenced in his report. What happened with Mr. Olson is that he walked in, he recognized Mr. Avery, and he assumed the rest from there. They've mentioned this prior fire with the Yaphank factory. And they said, well, you know, George Avery was there too. There was hydrochloric acid there too. Well, any person who has ever worked in a factory knows that every factory, every production plant has hydrochloric acid sitting around for cleaning. And so to bring that into evidence and say this is an accelerant or this is proof of anything more than that this was a factory in operation is ridiculous. And, you know, then they want us to believe that this shampoo caused the explosion. Like George Avery's MacGyver bringing in all these crazy things and setting a fire. They said, well, you know, there was shampoo on his shirt collar when we investigated it. Well, where else would shampoo be if it was on your person? Are we going to find shampoo on your shoe? You shampoo your hair, it could get on the collar. It makes sense. It's like saying, oh, we found a steak knife in the kitchen drawer, and that's supposed to mean something. And then they say, well, you know, there was this $5,000 check to Mr. Avery. Why would anybody in trouble spend this extra money? Well, look at the Hardee's commercials. Where has Hardee's been for the past 10 years? And now they've got these thick burgers, and they've paid Mark McGuire to come and endorse these thick burgers. Sometimes when you're in a desperate situation, you have to go for broke. You have to spend money to make money. And that's what Mr. Jackson did. Besides, why would anybody pay an arsonist with a check that could be easily traced back to him and to his business? Then they bring in the testimony of Marie Williams. Marie Williams, who had had an affair with Mr. Jackson, who had been promised that Mr. Jackson would leave his wife and leave his children and marry her. Miss Williams, who had been ditched for this supposedly, according to her testimony, new woman, Miss Peterson. Miss Williams, who had been fired from the Flinders Aluminum Company. And she's a reliable witness to testify as to what Arthur Jackson may or may not have done. Ladies and gentlemen, there was no arrest made in this arson. If Mr. Olson is so cocksure that this is arson, probably arson, seems to be arson, why wasn't there an arrest? Why didn't he charge my client, Mr. Jackson, of burning down his building? Why? Because there was no proof. It was all speculation. And that's what they want you to do, is to speculate today. They say, well, there may have been a spark. You know, he poured this stuff on the floor, splashed it around. May have been a spark. Or he may have had a timing device in a machine. Well, you know, there may have been a pink unicorn that set the thing. But what we have are the facts. And the facts are that there is no timer. The facts are that nobody saw a spark, that you can't prove a spark. The facts do not prove arson. In conclusion,
Running out of time, Leroy.
I'm done. Conclusion is that what is happening here is that the insurance company is not paying out on their claim after they have benefited for 10 years from Arthur Jackson and his money. In the law, we have what's called unjust enrichment. It's a contracts sort of an idea that when you benefit from something, when you receive money or you receive material gain from someone for nothing, it's only equitable and fair that the other party should receive its end of the bargain. Mr. Jackson has paid these premiums for a decade, and when he needed that policy to come through for him, all they can do is sully my client's good name with this charge of arson to keep from paying what is due to Mr. Jackson. All they've got to rest their entire case on is an angry, jilted woman and an incomplete report by a fire chief who has an axe to grind against Mr. Avery to begin with. And so that's why I ask you the jury to return a verdict for my client, Arthur Jackson, and his Flinders Aluminum Company for $1,667,000, because that is what my client paid for, and that is what my client deserves. Thank you.
Don't you,
I'm not going anywhere.
I'm not gonna let you. I think that that was the best argument I've heard with the use of common sense, things that happen, okay? Now, I just said something to Danielle about talking too fast. Not only are you talking too fast, you're stalking. And you'll see it on the video. Slow down, kiddo. You were doing well. And I don't mind you raising your voice or lowering your voice, but you're too excited there, okay? And just try to hold on to the edge of that lectern and not go from side to side. When you start off, Levi, he was defrauded or he was cheated out of his insurance proceeds, but he wasn't screwed out of them. There'll be 7 old women on your jury that will shut you off immediately and you'll never get the case to them, all right? Towards the end, you threw in a concept that won't be in any jury instruction, and you called it unjust enrichment. They're going to go back to the jury room and the wires are going to be coming out of their heads. Avoid stuff like that.
Could you bring in that concept, but maybe just
Call it
say
something else. People shouldn't profit by their own wrongs.
you can't get something for nothing?
For nothing, sure. But you did, I thought, some very, very, very good things. I liked your statement that Arthur Jackson was not a perfect man by any means. I mean, that's good stuff. He wasn't. But it has to be said. That doesn't mean that, as you said, because the steak knife is in the drawer, that someone used it to kill someone. The best statement you made was, I thought that, why the dickens would he pay an arsonist with a check? I mean, that's a strong point. And I liked it. I mean, some jurors going to go back. And one of the joys you're going to have in life, Nathan, I'm holding you up just a minute, is if you ever have an opportunity. And in the old days, we used to get away with it because we could kind of lean our chairs up against the wall and listen. And the judge would usually sit with us, and sometime he'd have a bottle of whiskey with him, and he'd say, "Wags, you're ahead. Oh, God, you're behind." And you would hear them talking about things that had nothing to do with the case, okay? They do that, and they still do it. But there will be, based on Levi's comment, that man didn't burn down his building. Do you think he's a businessman? Do you think a businessman would pay someone with a check to burn? He's not the Keystone Cops. I mean, that was a very, very good point. I thought you did a heck of a good job. You raised some good common sense things that you can use in your closing. There is nothing in the world better in a closing than common sense, is there? Do you agree with that, Michelle? I mean, that's what this is all about. Telling our story and doing it with common sense. You agree, Nate? Yeah. All right. You're on, kid. Now, look, here's what I want you to do. Nathan's going to take 10 minutes. Would you all want to stay with me for another